Happy Thursday, everyone. Today we're going to talk about the proposed changes to the TREC 1-to-4 family contract. The red lines are available for viewing on the TREC website, and I suggest you download them for reference. Small wording changes can make significant changes. The red lines will highlight those changes for you. Of course, the most relevant and necessary change to the contract addresses who pays commission. This is specifically addressed in revisions to paragraph 12 of the contract, which lists the expenses agreed to be paid by seller and buyer at closing. Under paragraph 12A1, covering seller's expenses, the phrase brokerage fees that seller has agreed to pay is added and takes care of the situation in which seller has agreed to pay the listing agent, the listing broker, and allow the listing broker to share the commission with the buyer's broker. New paragraph 12A1B, on the other hand, is to be used to contractually bind the seller to pay the buyer's commission when the listing agreement does not provide for compensation sharing. And revisions to paragraph 12A2, covering buyer's expenses, adds the phrase brokerage fees that buyer has agreed to pay, in the case where the buyer is paying their own brokerage fees. With the new contract, the Texas Realtors addendum titled Addendum Regarding Broker's Fees will no longer be necessary. Another beneficial change to the contract is under paragraph 6C1, the survey paragraph. The change was made to be consistent with a recently updated Texas Department of Insurance rule that allows for the adoption of providing a T47.1 declaration, which does not need to be notarized, instead of the original T47 affidavit when delivering an existing survey. Previously, if the buyers and sellers wanted to use an existing survey on the property, the sellers had to deliver to the buyer the existing survey and a T47 within a negotiated amount of days after executing the contract. The T47 affidavit, in which the seller affirms that no changes have been made to the property that would affect the survey since the date of the survey, had to be notarized. Without notarization, technically it was not an affidavit. It was simply a statement. If the seller did not deliver the existing survey or affidavit within the time prescribed, the buyer was entitled to a new survey at seller's expense. Many times, an unnotarized T47 was delivered with the expectation that getting it notarized at closing is fine. However, we have been in the middle of the situation before, where the buyer required the seller to order a new survey because the T47 wasn't delivered according to the contract, because it was not notarized. Getting to a notary within the 3-day time period that many of you put for the amount of days in paragraph 6C is hard for many sellers. So now, instead of requiring a T47 affidavit, the contract will now allow the seller to submit a T47 declaration, called a T47.1. It does have some additional language, such as all statements in this declaration are true to the best of my knowledge. I understand that any person making a false statement may be liable for actual and/or punitive damage. And it asks for the name, birth date, and address of the declarant, and it also says above the signature line, I declare under penalty of perjury that the foregoing is true and correct. There are a few more changes to the contract that we will go over in the next tip of the week. Stay tuned, and please give us an opportunity on your next transaction.